Call the Honourable David Parker.
One of the great mysteries of the House today, sir, has been why the computer system keeps going down. Well, if you see the length of this bill that people might have printed off, 1,226 pages long, maybe this is the reason. Mr Speaker, just before I commence my comments on the bill, can I just refer to one of the matters that arises from Jackie Dean's contribution? And I agree with what Jackie Dean was saying in respect of remand appearances and things being made simpler through electronic means. And I won't traverse some of the civil liberties that were just about infringed by the government's attempt to extend that to hearings of fact, where people could potentially lose their right to appear in defence of their own trial, because we did resolve that in this House. But her comments did remind me that I think we have an aberrant correction system when you create enormous prisons and site them in rural areas so that you've got many hundreds, if not 1,000 prisoners dislocated from the towns and cities from whence they come, put into a little rural area like Milton, for example, and as a consequence, the likely outcome when it comes to reintegration of them into the community is worse, because their families have had less contact with them while they're in prison. Their friends and support networks haven't been there. It's harder to integrate them into work because there isn't much work in those rural areas, and I think it's one of the unresolved issues that we've got in New Zealand yet, this idea that we should have these enormous prisons sited in rural areas rather than smaller institutions closer to the place where prisoners come from. Anyway, if I turn to this bill, Mr Speaker, Judicature Modernisation bill is a good thing. It's housekeeping legislation, bringing up the laws up to date and standardising some of the rules as between some of the senior courts and promulgating appropriate legislation for the district court as well. But it does nothing, it does absolutely nothing to improve access to justice. And unless you have access to justice that is practical, then the courts don't meet their social function, which is to avoid violence but allow for the just settlement of disputes. And disputes arise sometimes between well-meaning people on each side who can't agree. Those disputes need to be settled. Also, you have disputes where you have powerful or overbearing people on one side and weak and vulnerable people on the other side. And our courts need to be accessible to the weak and the vulnerable in order to protect their positions. And if you don't have that, then you actually lose respect for the rule of law, as well as encourage inappropriate, uncivil action in society. We call these civil procedures because they're meant to be civil. They're not meant they're meant to be civil, and they're meant to avoid uncivil behaviour. Now, we've got problems right across the Western world with access to justice, but New Zealand's no different. And it's getting worse in New Zealand. The length of period that people stand on remand before they get into a criminal process is far too long in New Zealand. People who are not guilty but are on remand are held in custody longer than they should. People who are guilty or witnesses should be brought to justice and convicted earlier. Witnesses shouldn't have their memories, shouldn't suffer the loss of memory that happens with time through long processes. In the criminal justice system now, because of changes to the way in which the prosecutorial services through Crown Law officers are being, Crown Prosecutors' offices are being funded, we've now got plea bargaining in a way that we never used to have in New Zealand a decade ago, and it's wrong. We have lawyers now who know the longer that they wait in the process in respect of guilty defendants for whom they're representing, they'll get a better deal because the prosecutors haven't got enough money to prosecute them. And we've now got serious assaults in New Zealand being categorised as minor assaults because they can get away with that in a plea bargain, and that is wrong. So I would like to see the government spending a bit more money on the courts. I think it is one of the duties of government to make sure our courts are effective. Now, that's not to say that money is the cure to all of these things, but it is relevant. civil arena is even worse. Do you know that the maximum income that you can have to get legal aid in the civil courts is $22,000 gross income, $22,366 for a single person, $34,420 of family income for a family with one child. There is virtually no one in New Zealand who is employed who's entitled to legal aid, but there are lots of people who are employed who cannot afford to fund a lawyer up front. And as a consequence, there are lots of things that are unjust in New Zealand that are not litigated, and that is wrong too. That is wrong too. Not just in the family court, and there are some innovations in the family court that I don't have time to go into that I disagree with as well, but in the civil courts. It is wrong. We now have the rule of law being broken down because contracts can't be enforced. If you can't rely upon your contract being enforceable for quite significant sums, well, again, you're undermining the rule of law. These points were made by Her Honour Justice Helen Wynne-Kelman in a report that my colleague Jacinda Ardern, a speech that my colleague Jacinda Ardern mentioned that she gave at the Ethel Benjamin address on the 7th of November last year, which was about access to justice. She also made the point that court fees have become excessive, and this is the legislation which provides effectively for the setting of those fees. Do you know now, in the simplest of cases really, that goes to the High Court, the court fees, by the time you have a straightforward proceeding involving a hearing of one day, the court fees alone, this is not the solicitor's fees, the court fees alone paid to the Crown total $6,700. It's amongst the highest rate in the world, amongst the highest rate in the world. And again, this is a block to access to justice, and I don't think we've got the balance right here. This is, I'm told, about 50% higher than the comparable fees in the United Kingdom, and it's a country which I think has a fine record of upholding justice. Now, one of the other consequences when you don't have accessible, cost-effective access to judges is you get a lot of people actually not even pursuing their rights, but other people do pursue their rights or defend themselves personally in court. There's been an incredible rise in the number of people who represent themselves in court. And Justice Wynne-Kelman says of the 228 active civil files in the Court of Appeal, 56, that's about a quarter, involve unrepresented litigants. In the Auckland High Court, 40% of all judicial review cases have one or more unrepresented litigants. What happens as a consequence of this is incredibly inefficient in the courts. It's incredibly inefficient because unrepresented litigants, they don't know how to prosecute their rights. It takes a lot longer for the judge. The judge sometimes has to sort of conflict themselves. We have an adversarial system. The judge is not meant to be helping either of the parties, and yet the judge is sort of either having to help one of the parties or asking counsel for the other side to help the party. And, if you're the other side, you don't think you should have to pay for your own lawyer as well as paying your own lawyer to help the other side. So all of these problems relating to access to justice are coming home to roost in New Zealand. As a consequence, I think most people in New Zealand do not think our courts are something that they can afford to use. And that's wrong. And for me, the courts are not serving their social purpose. Now, where does the answer lie? The answer lies a wee bit in a little bit more money from the government. It also lies in improved lawyer behaviour and judges taking control of their courts and stopping them being too much time wasting. Some shorter judgments. Too many judgments read like academic treaties at the moment, despite appeal rights, rely on appeal rights for things that go wrong rather than academic treaties at first instance. But, sir, I'm sad to say that this bill does absolutely nothing in respect of those problems that I have categorised in respect of access to justice in New Zealand.